Get ready. This is our 300th show and your chance to ask questions about family law, from marriage to divorce, from birth to death, and everything in between. Call or email in right now, live on a special hour-long The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
Tonight is your chance to ask questions. The topic is family law. The number to call is 1-800-375-4049, or email your questions to lawworks@wvpubcast.org. My guest is attorney J. Douglas Crane. In fact, you're our go-to family law guy.
Thank you.
You've done this a couple of times before.
Yes, I've always enjoyed it. It's wonderful to be here.
We appreciate it. Right now, there are folks trying to get to their telephone to ask the number one question that is always asked when we talk about family law. My son and his wife are getting divorced, and I want to see my kids, my grandkids. What can I do to do that? The grandparent.
Grandparents' rights in West Virginia. Well, actually, the statute says it's grandparent visitation. And the thing that I tell people is get along with your son or your daughter, whatever the parent is. That's the most important thing. There is availability to go to court, but if you read the statute, it says that whatever things the child live with me, grandchild, all these things I can do if the parent agrees, and that's the trump card.
And that's your child parent.
It's your child parent, the parent of your grandchild, be it son or daughter.
Well, and you said stay friends with your child. It's also a good idea to stay friends with your daughter-in-law or your son-in-law, because you want them to believe that the child needs you in their lives.
Right. Yeah, I have an expression I use that, and I try to tell people that a child can't have too many people that love it, which I think is a good thing. So if you can expand on that with the grandparents, and there's always at least two sets of grandparents.
Well, and it's hard, but you have to explain to people sometimes that it's your son or it's your daughter that your opportunity to be in your grandchild's life flows through.
That's absolutely correct.
If your child says, I want my child to see my mother or dad every weekend or every day or every time I have the kids, then you will. Mm-hmm. But if that child is alienated and says nope, or is gone, and sometimes your kids run off and abandon their children, you're not going to see anybody.
Well, Dan, in today's society, you have, I said at least two grandparents. You have a great many people who are divorced and remarried. So I have a grandfather and a step-grandmother, grandmother and a step-grandfather. And it goes, you could have as many as 8.
Well, you'd have more than that, depending upon how many times Grandpa gets married.
That's true.
And divorced.
Yeah, and all those people may have love and affection for these grandchild or grandchildren.
And it would be nice if they could all stay involved somehow.
All stay involved.
Well, one of the worst situations is when some child has 12 first cousins and doesn't know any of them. And that's what family is, but our modern society doesn't really promote family that much.
The old adage that it takes a village to raise a child, I think, is very true. And as I said, the more people that love a child, that is in the child's best interest.
Well, and I say often that the village is going to raise your child whether you want it to or not. Because once the kid is old enough to walk off the front porch, he or she is out there in the world. And it would be better if that village was comprised of your family members and your friends rather than people who really don't care about your child and who may seek to take advantage. And there are plenty of them out there.
Unfortunately, that's true.
Well, let's look at something else that's in the news. William and Kate are getting married here shortly.
Yes, they are.
And there has been much talk about the antenuptial agreement. What in the heck is that?
Antenuptial or prenup, but it's the same thing, and most people refer to it as a prenup because it's you entered into prior to the marriage of a couple. And as unkind as it is, it's the way a couple sits down and says, if we split up, this is how we're going to divide things. So you're trying to work out your disillusionment prior to the marriage, when everything's hunky-dory and happy.
Well, in basic terms, a prenuptial agreement or an antenuptial, A-N-T-E, not A-N-T-I. It's not against marriage, it's before marriage, A-N-T-E, is a contract.
Yes, it is. The primary thing that must be done in a prenup or antenuptial agreement is full disclosure of the assets of both parties. I can't enter into an agreement that says my net worth is $100,000 if my net worth was $5 million and expect my new bride to be bound by that contract. So you must fully disclose the assets and how those assets are going to be divided in the case of a breakup.
It does seem to take the bloom off the romance, though.
Oh, it does.
I've prepared several of these things over the years, and I've seen many others. And it seems that a common factor, or at least a frequent factor, is that the bride's father has done very well in life, and he's going to be giving money to his daughter, but he recognizes that his son-in-law to be is going to be sharing in that, and he doesn't care all that much for his son-in-law to be, and he wants to protect his daughter against losing any of his money.
Yeah, and a lot of times there's also a great disparity in income, where one party is making several $100,000 a year in their profession or work, and the other party may be making $20,000 or $30,000 a year. So the desire is to protect that ability to earn and assets and things that are acquired. The vast majority of prenups are coming on second and third marriages. And there's a valid reason that all of a sudden from the first marriage, one of them has children or things, and they want to preserve a portion of their estate for their children.
If you have questions about family law, marriage, death, birth, anything dealing with your family's legal situation, give us a call and ask your question. The number is 1-800-375-4049, 800-375-4049. Or if you'd like to send us an email, the email address is lawworks@wvpubcast. That's WVPUBCAST.org. We'll answer those questions on the air. Give us a call or send us an email. It also provides a mechanism that allows the better off of the couple, whoever's got the most money, to give gifts and to make provision for the other person, the spouse, without being obligated to do it into the future or without having to give up more than she or he might want to give up. We have put terms in it like, I might buy you a car, or I might buy you a boat, but I don't have to buy you a car. I don't have to buy you a boat. So that you can enjoy the fruits of my largesse, but it's not going to hurt me when the time comes.
Yeah. And obviously the rich and famous, Donald Trump, and has his prenups and things to go, and at least in the past has always seemed to do his divorces right before the big money kicks in. 5-year marriage, and he gets divorced in 4.5 years, or when things are, quote, vested.
Well, a wise business person will read the contract.
Yes.
And know what the terms are.
And I think people realize, I'm sure you get these calls too, where parties come in and say, well, I want you to do this for both of us. And you said, no, I can't. You need to get, if you're going to get into a prenup, you need to make sure that each person has their own counsel and attorney, because your interests are not exactly the same.
Well, sometimes I wonder if maybe we don't do that, meaning attorneys don't do that for themselves, because invariably, if you try to talk to two people at one time, one of them later on who's getting the short end of things is going to feel like they were betrayed by the way you gave advice.
Absolutely. As the old adage that I remember from law school is, the attorney only has one mistress at a time. You have one client, and you work with that client until that case is done. And you can't serve on both sides of the street. It's just not possible.
The term we usually apply to things like that is to say you have a conflict of interest. You can't serve two masters. You can't have two bosses. I've seen it in real estate transactions where one real estate sales agent, sometimes they're called realtors, that's a term of art, will try to represent both the buyer and the seller, and goes into the house and finds a crack in the basement wall. And he asks the seller, how long's that crack been there? And the seller says, we don't talk about the crack.
Yeah.
And the realtor says, well, I've got to go tell the buyer about the crack. He says, I don't want you to go tell the buyer about the crack. You're representing me. I hired you to sell my house. Now you have this buyer over here. You don't tell them about the crack in the wall. If they want to know about the crack, they can find out for themselves. And the realtor's in position and says, I have to tell them about the crack in the wall. It affects the value of the house.
And it affects his license if he doesn't do that. He or she doesn't do that.
It can do that.
Yeah.
And the same thing happens when you're giving advice to a premarital couple or in any kind of a case. Time after time after time, a couple will come to see an attorney and say, we want you to represent both of us in whatever it is. And you just can't. First of all, the law doesn't permit it.
Ethics doesn't permit it, and you can probably get by with it if they're buying a house and they want you to do the title work and do that. That's fine because you're getting deed to both of them, and there's no conflict there. Their interests are mutually tied together. But when it comes down to other things, it's just not possible.
Well, and that raises the other specter, and it's important for people to understand that if you have something like a house and your new spouse comes in and says something that translates roughly into, if you loved me, you would put my name on the deed, what does that do?
Well, again, we were talking about prenups and second marriages, and a lot of this comes up a lot, and there are people who get married and this question comes up. In this state, we have equidistribution, which is basically the fact that any asset acquired during the marriage is to be split 50-50. The exceptions to that are separate property, and separate property is property I had prior to my marriage. So if I owned a home, and maybe like it was paid for, and then I get remarried, my new spouse puts on, I've just made a gift to her of 1/2 the value of that real estate.
And otherwise, your new spouse has no real interest in the house unless you've invested joint monies into it to add a room or to build a swimming pool.
If it's paid for, but now if when we got married I still had a mortgage of $100,000 and for the next 10 years we paid the mortgage down, then that's marital funds have reduced that mortgage payment and paid it off and gives her a value in the increased value of the house. Say the house was worth $200,000 when we got married with a $100,000 mortgage. 10 years later it's paid off. She doesn't have a half interest in the 200, she has a half interest in the 100 that we reduced it down.
And if you're fortunate enough not to have a mortgage on it and you just own the house outright, that house continues to be yours unless you make a material investment in it.
Improvement, yes.
And then your spouse will have a half interest in the increase in the value as a result of that material investment. But these things are very difficult to calculate. It can take a team of theoretical mathematicians sometimes to figure it out. But that's what prenuptial agreements are for, is to define those terms, to define who's going to get what and under what circumstances.
Right.
Very famous case in West Virginia, though, well, I'm not going to mention names, but a very successful businessman decided to give a gift to the new couple. The bride of the new couple was his daughter. And he said, I will build you a nice home and I will give it to you. And he had a deed prepared to daughter and husband, and that was a gift of half the house to the husband.
Absolutely.
And when the divorce came, he was not happy.
Yeah, and I see a lot of where parents in love of their children want to help them out. So when Susie and Billy get married and they want to buy a house, but they don't have the down payment or they don't.
We see this all the time.
Yeah, helping your children out. So mom and dad, grandma and granddad come up with 20 grand to help out their children, son and daughter-in-law or daughter and son-in-law, whatever the case may be. And that's great until 8 years later when all of a sudden there's marital discord and they get a divorce. And the parents say, by the way, that was a loan. I want my 20 grand back.
That's usually said the day before the hearing.
Yeah. and that's not a loan, that's a gift, unless you have a note, deed of trust, or some evidence that that was a loan and not a gift.
And the problem with that is if you do prepare all the paperwork, have your lawyer prepare all the paperwork to show that this really was a loan and do it when the loan was made, then you're going to have to go to the bank and say, well, I know I'm trying to get a loan from you, and no, I don't owe anybody else any money on this, and the down payment I came up with myself. You have to lie to the bank because you're not telling them about Grandpa's loan to you for the down payment. So these things don't work out real well. We do have some phone calls. First one up is Ed in Wood County. Ed, go ahead with your question.
Good evening, sir. Just a quick question about temporary support and when it's ordered in a preliminary hearing. I was wondering, does that order have to be entered by the judge the next business day?
No, generally in a temporary hearing, the court speaks to its record. Did you have attorneys involved, sir?
Yes, I did.
Okay, the court will generally give them, each court is a little different, but at least 10 days to transcribe that, get the hearing, get it reduced back, send a copy to the other attorney. If it goes out on a 5-day notice so that they can look at it to make sure that it is correct, and then after that 5 days has passed, then the court will sign the order.
Yeah, to summarize that, the courts usually have standing rules that say orders will be submitted within 10 days after the hearing.
10 working days.
10 working days after the hearing. But as a part of that, when the order is submitted, a copy goes to the other attorney, and the other attorney has 5 days to raise issues or to make objections. So in theory, if everything happens the first moment that it could happen, that would be a 15-day period before the judge is going to look at the order to sign it, absent some emergency situation, and I can't really speculate about what that might be. Typically, though, on support orders, you're talking 10 to 15 days, and actually maybe a few days more than that if there's a good reason not to get the order in right on time. If the lawyer gets sick and is gone for 5
and
or
I've
6
seen some
days.
judges who will, from the bench, write a temporary order because of the Bureau of Child Support Enforcement or some reason it has to be done instantly, and that's done, a very short order to that effect.
Temporary orders, courts try to be responsive to those things,
yes.
And particularly in issues or in situations where safety of pretty much any sort, from violence or just food, shelter, clothing, medical care. When those kinds of things are involved, judges oftentimes will write the order themselves as a temporary order.
Right there at the hearing.
Right, yes. I've walked out of many hearings with an order in my hand.
Yes.
And as technology advances and we get a new generation of judges who are computer literate and savvy, frequently those things do happen more smoothly. But there are instances where there are considerable delays.
Yes.
And if there is a real considerable delay, you ask your attorney to call the judge's office and ask if there is some reason why this is being held up. And oftentimes that'll shake the system a little bit.
And most judges I know have a tickler system that they had the hearing on this day and it's 15, 20 days, and their clerks will go, "Where's that order?" And they will be calling the attorney who was designated to prepare that order, and you better have a good reason why that order is not on the judge's desk. We
have another call. Kelly in Wood County, you have a question.
Yes, good evening, gentlemen, and thank you for taking my call. It seems like the cases in family court just drag on forever, and more specifically, in Rule 59, it says that there should only be 75% compliance at 240 days. And I think in some ways that seems a little high, because it seems like they're not meeting that standard, but in other ways, shouldn't that standard be set a little higher?
I'm not sure I understand what your question is. Are you talking about the number of overnights a child has with a parent?
Supreme Court says 75% of the cases should be resolved within.
Yes, the Supreme Court has issued guidelines about the expediency of handling cases, how quickly they're supposed to go through. Those are probably more honored in the breach than in the observance.
Yeah, sir, these are guidelines, and I've been in family law for quite some time, and I'll tell you that each case is unique. You can't sit down. Family law is the most difficult, the most trying, the most interesting, it's the most personal. There's nothing more personal than you, your wife, family, children. Some things can't be rushed.
And there's no area of law, except perhaps for a capital punishment case, where there is more at stake.
Oh, absolutely.
If people disagree about what the meaning of the word is.
Yeah. As I took that from the Supreme Court, these are guidelines, but you wouldn't want your case rushed through if there's information or things you can't get. There are a lot of cases that are they're done in 30 days, but there's some cases that may take a year and a half or two. I would tell you that I believe it's sincerely the The two parties have a lot of control over that. People that are sit down and reasonable and can come to some compromise don't stay in court for 2 years. People who want to litigate everything, the court has a limited amount of time. There is a tremendous amount of people in family court, and you take like going to the deli, now serving number 27.
What do you want?
Yeah, and get that time and move on to the next.
Yeah, they don't want you to stand there and read the menu when they ask you for your order.
I believe the court system is a service to the people of West Virginia, and I say family law is something that is I think the most serious thing there is, and some things just can't be rushed.
Well, and judges don't want to make a hurry-up decision just to get a case moved off of their desk.
No. When you're dealing with children, and you just can't gamble with that.
Well, Doug, how many times have you seen a judge who is one of the best people in the world? Now, certainly judges, just like everybody else, comes in different flavors. Some are studious, some are relaxed, some are eager to get a job done, some are a little more laid back. But the best judges are the ones who read, consider everything in the case, and who strive to do the right thing. Unfortunately, striving to do the right thing will sometimes, in fact frequently, slow down the process. The judge may want more information, and that adds to the time.
If you've got a 10-year marriage, and in that 10 years you have 2 or 3 children, there's a tremendous amount of things that happen in that 10 years involving your 2 or 3 children. The court is not going to give you a 10-year hearing. It's got to be condensed down. And to get all the facts that are pertinent, it may take a while.
Well, but there's a cure for this. If you and I, heaven forbid, are getting divorced, don't get too locked up in that. But if you're getting divorced, the best person to go to work out the kinks in the divorce is in your mirror, and the other person the same way. The two of you need to talk and reason, negotiate together. And inherent in the word negotiation is, I'll give a little bit, you give a little bit, we'll meet somewhere in the middle. Wish you could do that in Washington. Wouldn't that be nice?
Yes.
But otherwise, you're leaving it up to the judge, who, even though she or he may be the best person in the world, may be the best judge in the world, really doesn't care about you a whole lot. You're another case on their desk. They'll try to do the right thing, but they can't worry about the things that you worry about. They don't worry about the sentimental value of the bath towels that you got from your grandmother or something like that.
I do a fair amount of mediation where I'm dealing with moms and dads, and the one thing I tell them is that mediation is their chance to have total control. And if you can't work out total control with the parenting plan for your child or children, then it'll be decided by Judge so-and-so, because he or she will make that decision for you. So now's the time you're in control, and this is something that can be worked out.
And one of the problems with that is sometimes the judge will form opinions about you or the other person, and those opinions may be well-founded or they may not. Many times I have seen people go into a courtroom and present themselves so badly that they irritate the judge, and judges are people. And if they don't like you, they're going to tend to not give you perhaps the credibility you feel you deserve. Sure. And when it comes time to splitting hairs, you may not get the half that you think you should get.
Split the other way, yes.
We got an email question. This is from Sharon, and she says, my fiance and I have been together for 9 years. I have no children. He has 2 adult daughters. We recently made out our wills, leaving our estates in entirety to one another. And my question is, can the daughter he excluded intentionally from the will due to her attitude toward me contest his will, which leaves her nothing? He put in a contest clause in his will. A contest clause is a clause that says, if anybody comes forward and contests this will or objects to the terms of this will, then I disinherit them as if they didn't exist. But if this person's not in the will to begin with, that clause really doesn't apply to them.
And not having seen the will, he may have put in that he gave his daughter $1, and that or the statement that was in one of the people in Hollywood said, I know I have a son and I specifically disinherit him. There's no law that says you have to give your children anything.
No, that's absolutely correct.
You know, and so if not having looked at his will, but it sounds like if he went to an attorney and had it drafted up and when he does not have to give his daughter a penny, the fact that she's his daughter doesn't mean she automatically inherits anything if he has a will. Well, a reason to get to an attorney and make sure you have wills and don't go intestate.
Do not go to a stationery store, a bookstore, a big box store, and buy something that purports to be a will that will serve your purposes. Don't go online to some service that says we've developed all these forms to protect you and here's your will. Go to an attorney. It sounds as though we're trying to feather our own beds, and I suppose in one sense it serves that purpose, but wills are unique to the person and the circumstances. Now, the basic question in this email question is, can his daughter contest the will? The answer to that is yes. Anybody with the filing fee can go down to the courthouse and file a lawsuit, can file a will contest. The important question that you may ask yourself is, if she contests the will, can she or will she win? We don't know. It's going to depend on the circumstances.
What's in the will.
And the way the will is written. That's why it is so important that you have somebody who knows what they're doing write that will. And there are a lot of good attorneys out there who can prepare a will for you. Wills need not be terribly expensive, no. But if you've got a complex family situation, you should expect that your will cost maybe some dollars, some significant dollars even, to write because of all the contingencies that happen in it. Things happen when you die without a will that you might never have envisioned. Yes. And I remember one situation that I saw where a fellow was madly in love with his second wife, had just married her, he had a couple of adult children, and he sent her what essentially was a love email saying, everything I've got is for you, take it all, it's for you, I love you madly. It meant nothing. It was not a will because it was not properly executed. In fact, it wasn't executed, that means signed, at all. His adult children came in and said, we don't like her. She took him from our mother, or she took him after our mother passed away and he forgot our mother. We don't like her. They got it all. She got really nothing. Because if you die while you're married without a will and you have children by another relationship, your new spouse takes 3% of your estate for each year of your marriage. And 3%, 6%, 9%, when you're talking about a modest estate, really isn't worth fighting over. You just can't do it. Domestic violence orders.
Yes.
We see a lot of them.
Yes, we do. Unfortunately, too many.
We sigh when we see them. Why do you say we see too many?
I've said this before. I think domestic violence, if there is one domestic violence case that is appropriate, that's one too many. A man or woman that is a victim of domestic violence is unacceptable. That having been said, there are some cases where the system is abused, where people will go to the magistrate and get a domestic violence order to get a leg up because it is no hearing. It is extraordinary remedy, which means there's no due process, which is why the Supreme Court says that once that order is issued, there must be a hearing within 10 days because I have kicked you out of your house, I've taken your, whatever it is I've done, of the extraordinary remedy, and now that's not going to last more than 10 days. So you can get in front of a judge, generally a family court judge, and hear your side of the case because there's no evidence whatsoever other than a statement made by the petitioner. And
both sides get to show up and present their evidence.
Right.
The problem in those cases is evidence. Now, certainly if someone is the victim of physical abuse, there is likely to be evidence. There are going to be marks, there are going to be witnesses who have seen scabs or scars or tears in the clothes, heard children crying perhaps. Those are domestic violence cases and courts deal with those well. But when it's a she said, he said situation, boy, as evidence, it's evidence.
Well, and psychological abuse is more damning than physical abuse. And that's very hard to get evidence on. Very difficult.
We're talking about family law and taking your questions. My guest is attorney J. Douglas Crane. I'm Dan Ringer, and this is The Law Works. The number to call with your questions is 1-800-375-4049, or you can email us at lawworks@wvpubcast.org. And we have a caller with a question about domestic violence. Sue, do you have a question?
Yes. Yes, I do.
Go right ahead.
Well, it concerns my son, my only son, and he was a victim of domestic violence from a ex-fiance. And after the trouble began, the police told him to leave his house, and they went before a magistrate. He was told that he should drop the case, but she was to leave his home and take only what's hers, and he unfortunately put her name on the deed, and she was told to get her name off the deed for that.
Who told her to do that?
The magistrate.
Okay.
See, she didn't even have her name on the loan. My son did.
Okay, your son had a fiance before they were actually married. He put her name on the deed to his house.
Yes.
Okay, he had a loan that he was paying off, and then the marriage never took place.
Right.
He was a victim of domestic violence.
Yes,
Okay.
her.
Okay, what is your question?
My question is, we got a lawyer. He sent her a letter telling her to sign this so that the house would be only his, take her name off, and we have not heard a thing.
How long has this been?
The letter was sent in January.
Okay.
Get with the attorney and follow up and see why there's been no response.
The law of a situation like this can be very, very complex.
Yes.
What happens is if you give somebody real estate, you give it to them by putting their name on the ownership papers, the deed. Now, that is basically a gift. If you were selling it to them and they didn't pay you, you could argue that they didn't fulfill their half of the bargain. It's called a failure of consideration, and you can void that transaction and maybe have that deed set aside. That's not exactly what you're talking about here.
And you may not like it, but she may own 1/2 interest in your son's house.
You could, I suppose, argue, but it would take some...
You have to go to court then.
You'd have to go to court, and you'd have to have some good evidence of it, that the gift of the house was given in contemplation of marriage, and since the marriage didn't take place, the gift should be set aside, and the judge could appoint a commissioner to execute a deed to convey the house back to your son. The problem with that is, to get a judge to sign a document like that, you have to be in front of a judge, which means you have to file a lawsuit, which means you have to go through a lot of steps and most likely a lot of months before that gets resolved. The domestic violence issue brings up another matter, and that is female on male domestic violence. It does happen. It's being recognized more and more, but the simple fact of the matter is most domestic violence is male on female. That is where the male in the relationship is the one who is violent toward the female. But it's just as valid one way as it is the other. It's violence is violence, and there's no excuse for it.
Unacceptable, yes.
But I suppose this focuses on something that we're seeing more and more in our society, and that is people acquiring assets without having a business or a marriage, people having children out of wedlock, as we call it, without being married. There are repercussions to those actions.
Oh, yes. You don't have to be married to have children. That's for sure. And again, as you said earlier, if the people are reasonable, they can work through this stuff. It's when they become unreasonable, and it's always the other side that says I'm reasonable, but the other side isn't.
Yeah, you're the unreasonable one in this relationship.
Yeah.
It's not me.
Generally, there's enough that's both sides need to give a little bit.
Well, one thing that is important to understand is what is a marriage. Now, in Western culture, we have, for hundreds of years, wanted to believe that marriage was about love and a desire to provide for another person. In other cultures, they see it in different ways. But still, no matter what culture you're in, a marriage is at its most basic level a business.
A partnership business.
A partnership business.
Yes.
And it's a business for the acquisition of assets, houses, cars, dish towels.
Retirements.
Retirement.
401ks, stock options, etc.
Life insurance policies.
All that, yes.
And the production of children. Mm-hmm. And if you look at it that way, you begin to understand premarital agreements or prenuptial agreements. You begin to understand negotiations in divorce proceedings. You begin to understand why one lawyer doesn't represent both parties. If you think of it as a business decision, whether it's getting married or getting divorced, all these things come into focus. It's when you let all this love and sex and stuff like that get in the way that it becomes a problem. And I guess that's why we have so many problems, is things like love, sex, lust get in the way.
It's so easy when it's not your case, it's not your wife or ex-wife, or not your husband or ex-husband, your children, which is another reason why you go to an attorney, is the attorney is not emotionally involved. He or she can sit down there with you, hopefully look at this with a stand back and see the forest for the trees and not be so emotionally involved that I don't want this, I just don't want you to have it. And doesn't make a lot of sense. It happens too much.
Attorneys can be objective. When they're in a courtroom, we have, our system is basically adversarial. I will advocate for you, Doug will advocate for his client, and that may be a very contentious advocacy. I may argue that Doug's client is full of beans and just completely wrong, and he may say the same thing about my client. But when we get back to our office with you, we will try to be objective about the situation, and you should listen, and you should go before the problem blows up. We have a question from Nancy in Marion County. Nancy, you there?
Yes, I'm here.
Go ahead, please.
Okay, my husband and I had our wills made, and of course, with going to each other, and then we had appointed our oldest son as administrator or whatever, executor, or I've been through this with my mother, but I don't remember what I was called.
Be the executor.
Okay. Anyway, he has passed.
Your son or your husband?
My son.
Okay.
Sorry to hear that, man.
So I need to know what I need to do. Like, our home was bought by our youngest son because he wanted this property, and he gave us lifetime rights. So that was done many years ago. No problem. You know, you won't have any problem with that. But what I need to know is now I need to appoint him as the executrix, and I don't know and then I need to specify such as diamonds going to what grandchild, coins going to what grandchild. Those have to be specified so there'll be no arguments in the family.
All right, ma'am. Mm-hmm. I always tell clients when we do a will that I would love to do the perfect will, but you've got to tell me what the future is. And since you can't, the best I can do is about 98, 99%.
I'm at about 95.
Oh, well, okay. Well, but when you do a will, you need to review it every 2 to 3 years, which is why I don't like and put a safety deposit box, because you generally think of reviewing these things on a weekend and the bank's closed, you can't get to them. Anyway, you need to redraft your will, and you need to put in who is the new executor, and you need to put in those special bequests that you're going to have for your grandchildren. It's just that simple. You need to sit down with who your attorney is, and you might make a list of the special jewels and things for each of the grandchildren and incorporate that in the will. I would also suggest that if you have, do you have other children other than your youngest son?
Yes, I have a daughter also.
Okay. You might put in that to provide for this is that whoever you decide to be your new executor or executrix, and if they are unwilling or unable to serve, have someone in the second place.
You've got actually a multi-layered question here about wills. Your initial question is, the person I named to be the executor of my will is now deceased and I need to name somebody else, or the circumstances have changed and I want to name somebody else. Just because you name somebody in your will to be the executor doesn't mean they have to do that. It means that they are your first choice to do that. They can decline. So in the short term, I would suggest you go to that person and say, the way things have changed, I think it's better if Junior over here serves as executor. Will you agree to that? And let them know that that's what your wishes are. Then, as Doug suggests, you need to go to an attorney and you need to redraft your will, but you need to plan for that visit. You've heard the phrase perhaps from time to time that you are your own best doctor. And that is said because people believe that you know where it hurts, you know when it started, you know what you can do to relieve it or what you do to make it worse. The same is true with being a lawyer. You can be your own best lawyer. That doesn't mean you should attempt to draft the instruments or write the contracts, but it means that you know what is important to you. You know what it is you want to do. You need to sit down and put your wishes, your goals, in an easily communicable form. Make notes.
Yeah, and take those notes to the attorney and say, this is your job. This is what I want. You make sure it happens the way so that it's covered.
And then make sure that when that will is prepared, you read it before you sign it.
Carefully.
Read it very carefully and ask lots of questions. Wills, probably as much as any document we prepare, is full of legal language.
Oh, absolutely.
And that language exists for a reason. Over hundreds of years, we have developed a system of jargon in the legal profession because each of those words of jargon has a very specific meaning.
Per stirpes.
Per stirpes, yeah. Ask somebody to explain that. We can, by the way. We're not going to right now. But yeah, we know what that means. You don't. But in a will, you're very likely to see that phrase. So stop everything and ask, what does that mean?
Ask your attorney. So you're absolutely crystal clear of what your wishes are and they're being met by that document.
The best clients that I have had in the preparation of a will may go through 2 or 3 drafts of the will until it is what they want. And then, as Doug says, every couple of years, take a look at that document and make sure you understand it. I typically provide to my clients the will, the original of the will, and only the original of the will document has any real meaning. There are a few very unusual circumstances where a photocopy of a will might be given some credibility, but the general rule is no, it doesn't count. Only the original counts. So secure that original will somewhere other than in your house. Give it to your sister or your brother. Give it to the child who's going to inherit the most so that they can produce that will.
Especially who the executor or executrix needs to know where it is in case something happens to mom or dad.
And then keep a copy in your home so you can look at it
and review it
and discuss it with your family if you choose to do that. But no one has the right to know what's in your will. Even the witnesses to your will do not know what is in it. They are only witnessing your signature. They don't get to read the will.
That's correct.
We have another phone call, I'm afraid. Lisa, you have a question for us in Summers County.
Yes. Good afternoon. I did a petition against this guy a few months ago, and I went and I had proof. I had my family here, and they witnessed it. But an ex had blemished a firearm and domestic assault, so I got a domestic violence petition against him. And then I went to a hearing, and they granted me 90 days. With that, I took proof of where he was standing and everything, the whole 9 yards. I had proof, and even where I had told him not to come here. But anyway, my question is now that it's the West Virginia is supposed to be taking this case, and it has him based up on domestic assault and brandishing a firearm, and plus there was a minor child here that has not been yet acknowledged. I don't know where to go from here.
Okay. Is your question, ma'am, that there are pending criminal charges being brought in the county where you reside? Is that what?
Yes.
Okay. And you got an emergency protective order, which they granted you at least a 90-day time, which I assume he's supposed to stay away from you, your place of employment, your home, the standard language in that order. So you have, is that correct?
Yes.
Okay. The police have, I assume, investigated this, and they may be in the middle of their investigation. I don't want to speak for them, but it is the county which you reside. If they find sufficient evidence, then they will get to the prosecuting attorney, and they will bring an arrest warrant for that once they verify the things that they need to verify, be it the counties, the cities, or the states. In what county is she in?
Summers.
Summers County, yeah. So these things don't happen overnight, unfortunately. It takes a while for them to do their investigation, which is why you've got the 90 days for him to stay away. And I believe if you go back and that time comes up and you still have, you can get that extended for a period of time, up to 6 months or longer.
Right, because, I mean, someone doing something like this, it kind of scares us females, and, the 90 days will be up before you know it, and if the prosecuting attorney hasn't done anything, then you're back being afraid for your life again.
You can get that extended through the magistrate, and you also, I would also suggest that you keep a copy of that order on your person. Don't leave it somewhere where you don't have it.
Exactly.
You also had asked another question about a child who has not been acknowledged. The paternity is in question?
No, I'm just saying there was a minor child here at the time, and they didn't bring that up, and I have since found out that that's where he did all these things, and there was a minor child here. That is considered a child endangerment.
It can be. Are you in communication with the prosecutor's office in Summers County?
I tried to call, and she's supposed to call me back, and I haven't heard a thing.
Okay, the police are investigating, but they haven't filed charges yet. Is that correct?
Well, they have the charges. Like I said, I in front of me. I'm looking at what the charges were, and he spent less than 12 hours in jail.
Well, he probably posted bond.
Yeah, he can post bond. That's still a right in this country.
Right.
Is there a chief investigating officer assigned to this case? The police officer?
I'm aware of.
Is there a police officer? Is there a police officer with whom you've been communicating?
No, not since all of this. Since the 90-day petition was granted, I have not been in touch with any law enforcement at all.
You said there are some kind of charges or things down there. Where do those come from?
That is from the night that he was here and had come to my house and was told not to come numerous amount of times on cell phone and everything, and that's where the charges come from.
Okay, is he still bothering you?
Not at this time, no.
Okay. Your situation is that things are working the way they're supposed to be working, I think. The investigation, the filing of charges, the prosecution of the case all take time. But if he attempts to get in touch with you, if you find yourself in places where he seems to be following you or seeking you out, call the police. Tell them you have this protective order and that he's still around. They will go visit him.
Yes.
And if there is more to it than that, they will bring him back into court. That it's your right to call the police if you need to call the police. But right now, nothing's happening. You're afraid. That's understandable. You're just going to have to give it some time.
Yeah, I mean, even on the 90-day petition, the judge even told him not to even let them, he better not even be caught with a shell in his pocket.
Well, yes, I understand that. But it sounds as though things are working the way they're supposed to work. Let them work. You might want to call the police if you remember the name of the officer you spoke with at the time and tell him that you're worried and ask him how things are going, maybe for a status report. I don't think they would object to that. But right now, let due process take its course. Thank you for your call, Mary.
Yes, ma'am.
Or Alicia, I'm sorry. Mary in Kanawha County, do you have a question for us?
Yes, this is in regards to a divorce decree. And at the time when I got the divorce, I was awarded an interest in some property. However, at the time, the property had, on paper, had a zero. It was more mortgage than it was.
There's no equity in the property.
No equity in the property. But the thing of it was my home, the marital home, I had to sign over was given as kind of, well, how would you say it? Was given up as collateral, I guess you would say, so that we could buy this property. And then with the intent that it later, into retirement, that it would pay off. So, the judge said
what is your question, Mary?
Well, can I reopen and ask for a share in that on what its value is now? It's like 20 years later.
Okay, your husband, in the divorce decree, your husband was given this other property and you were given your house. Is that correct?
Well, it was an investment property.
Okay, the question is, 20 years after your divorce, who owns your house? You. Is that right?
Well, we had other property too. So
yes, ma'am.
He got a house and I got a house.
Okay, this raises an important, Mary, this raises a very important issue. When you talk to your lawyer and your lawyer asks you a question, answer that question and then we can develop from there. You have your house, right?
Yeah.
And he has the other property?
Well, he has another house.
The property that you're talking about wanting to get back?
When the property, what I'm wanting to know is if I can get my share of the investment that I was put at risk for, and that I was I was put at that I was part owner, but at the time it said yes, but it had a value at that time of zero.
Okay, so ma'am, at the time of your divorce, and I take it was some 20 years ago?
Yeah.
At the time, the value of things you got, your husband got a piece of property that was worth zero, and you got the marital home that had some value. Is that correct?
Well, this was like a business proposition.
I understand that, ma'am, but the court is looking back that if you got divorced 20 years ago, they're looking at the value of the properties at the time of the divorce, the date of separation. The fact that it's increased in value over the 20 years. How much money did you put in that property that your husband has? Did you make any payments on it?
No, but at the time of when we were making the investment,
but the divorce.
I was at as great risk as he was.
But no money came out of your pocket, and at the time of the divorce, you're telling me that that property was worth zero. So your husband got a zero property, and I'm sure it had a mortgage on it, of which apparently you're telling me that he paid it all, even though your residence was put up as collateral. There never was a claim against your collateral. You never had to pay a dime, and now 20 years later or some, the investment property is now paid off and worth whatever it's worth. Is that correct? Have I got the facts right?
Yeah.
Okay. You got your value at the time of the divorce, and I don't feel that you can go back at that time and what I would call double dip.
When decisions are made by the court, unless there was fraud to cause the court to make a decision a particular way, you're pretty much bound by that. Once you recognize that something was done improperly, like fraud, you have a duty to come forth essentially immediately to create a remedy for that, if a remedy is possible. The fact that 20 years later you look back on it and you think, I didn't get a good deal out of this, or I wasn't treated fairly, you probably don't have an opportunity to go back and have anything changed at this late date.
And that's the doctrine of latches, is that if you sit on your rights too long, even though you may have very good and valid claim, you sat on too long and the court will say no.
All of this is basically part of the rule that cases must come to a conclusion at some time. Yeah. And when that conclusion is reached, unless there is an appeal of the decision or a petition back to the court to reconsider the decision, and all that has to be done within a period of just very few months, an appeal to the Supreme Court or an appeal back to the judge, There's nothing you can do about it. But thank you, Mary, for your call. Wish we could be more positive for you. It's a complex business we've got here, Doug.
Yeah.
J. Douglas Crane, attorney. Thank you, Doug, for being with us.
My pleasure, sir.
Thank you also for being with us. On behalf of the Law Works, we thank you for joining us on our 300th program, and good evening to you. If you have a legal problem and want to know if you need a lawyer, you can discuss your problem with a lawyer by calling 1-800-642-3617 Tuesday evenings from 6 to 8 p.m. That's 1-800-642-3617. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks program topics and additional information about this show's topic. If you would like to recommend this program to a friend, you'll find a video of the program at the LawWorks website. You'll also find free video and podcasts of previous programs on YouTube and iTunes. If you would like to suggest a topic for a future program, or if you're a school teacher and would like to receive a free copy of this show for classroom use, send us an email to thelawworks@comcast.net.
The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
From West Virginia Public Broadcasting.